Hey, it's Terry Gorry, and this is the Irish Law and Small Business Podcast. I want to take a look in this video at the High Court inquiry yesterday into the arrest and legality of Simeon Burke and his detention in custody. He has a district court hearing coming up on Monday of next week dealing with a public order offence arising from the antics in the Court of Appeal a few weeks ago. But before I do that, before I dig into it, I want to get my priorities right, and I want to feed the birds. So I need to get some bird feed first, then we'll deal with Simeon Burke and his High Court application yesterday, at which we had the remarkable sight of Simeon Burke making what the judge described as outlandish and baseless about the Gardaí, and then declining to cross-examine their evidence when they went into evidence, and notwithstanding the repeated invitations of Mr. Justice Cregan to Mr. Burke to cross-examine them and test the evidence, he declined to do so. In fact, he declined to hang around when the decision of the judge was being handed down either, and he sat in a side room, apparently still in custody obviously, and his family, I think, had gone home at that stage, according to the reporting in the newspaper. And I'm going to have a look at the reporting in the newspaper. But as a general proposition, if you make allegations about somebody, if you make serious allegations about somebody, and they come along then and they give evidence on oath, and you refuse or decline to cross-examine them, you really have to wonder about that decision. You'd really have to wonder about what you're trying to achieve. Okay, now that we've the birds sorted out, let's take a look at the reporting on the Simeon Burke High Court investigation. Today is Saturday, yesterday was Friday, it finished yesterday. Justice Cregan, I think it was, who presided over the court and the investigation into the lawfulness of the detention and indeed arrest of Simeon Burke arising from the incident at the Court of Appeal. In any case, Simeon Burke is facing a district court prosecution on Monday of next week in Cloverhill District Court for its public order offence, basically for resisting arrest and being aggressive and so on towards the Gardaí on that occasion when he was dragged out of the court by the Gardaí. And obviously there was a lot of behaviour which Mr. Justice Cregan has described as outrageous. Mr. Justice Brian Cregan, he said that Simeon Burke made wild and unfounded allegations against the Gardaí. He has decided that he's lawfully detained on a public order charge, and his trial on that charge next Monday can proceed. Mr. Justice Brian Cregan delivered a lengthy judgment on Friday evening. I'm relying on the reporting, for your information, of Mary Carolan in the Irish Times. I also follow Orla O'Donnell of RTE, and I follow both of them on Twitter. And Mary Carolan has done an excellent service there in covering these matters in the last while, because following her tweets you're obviously bang up to date in what's going on in the court and so on. And then obviously she writes the articles in the Irish Times and summarises the whole situation. But it's Mary Carolan I'm relying on today. Just Mr. Burke and members of his family were removed from the Court of Appeal by Gardaí that day after the disruption of the delivery of the Court of Appeal judgment dismissing teacher Enoch Burke's appeal over orders requiring him to stay away from Wilson Hospital School pending a disciplinary. That was the major, or the infamous kerfuffle as it were, where Simeon Burke was dragged out, and I think Enoch Burke was holding on to a bench in the Court of Appeal, and some of the others were removed forcibly as well. But Simeon Burke was arrested and he was charged with a public order offence. He declined to take up bail, and he argued that the process which led to his arrest and detention was unlawful. On Friday following an inquiry sought by Mr. Burke under Article 40 of the Constitution, Mr. Justice Cregan says that it goes without saying that it was disgraceful the way that the Burke family behaved in such a way in the Court of Appeal on March the 7th. It was even more astonishing, he said, that Amy Burke, a qualified solicitor and officer of the court, and Simeon Burke, a graduate of the King's Inn, should behave in such a way in any court. He said that Mr. Burke's conduct during the hearing of the inquiry into her brother's detention, or rather Miss Burke's conduct, was completely unacceptable. Mr. Burke himself had refused to engage with his own inquiry and had constantly repeated the mantra the inquiry was not being conducted in accordance with law and the Constitution. Mr. Burke, he noted, could walk out of jail this evening, but said he could not do so. He could walk out of jail this evening because all he had to do was sign the recognizance, the form which would release him on bail. But he said he could not do so because he's a man of principle. The court found it difficult, however, to see what principle Mr. Burke was standing on. He had no right to disrupt the business of the court. He rejected Mr. Burke's claims that he was not properly arrested. He held that both his arrest and detention was lawful. No excessive force was used, and there was no conscious or deliberate violation of his constitutional rights. About 12 Gardaí had made statements about the events of March the 7th, and their evidence about the circumstances of the arrest and detention of Mr. Burke told a different story, the judge said. Mr. Burke had been described as highly aggressive and abusive towards Gardaí, to have made obscene statements about transgenderism, and to have been totally frantic when a Garda was attempting to handcuff him. The Garda evidence said was that they had complied with the law in their dealings with Mr. Burke, the judge said. It was completely unacceptable for Mr. Burke to make wild and unfounded allegations the Gardaí were telling lies. It was also completely unacceptable the Gardaí were called to give evidence, and then Mr. Burke simply refused to cross-examine them. He had, at his own request, Mr. Burke, he was not in court for the ruling at 6 p.m. on Friday and remained in another courtroom with a prison escort. His sister, or his parents, Sister Amy and brothers Isaac and Josiah, who were in court earlier, had absented themselves deliberately for the ruling, the judge was told. Mr. Burke has been in detention in Cloverhill Prison since March the 7th, pending his district court trial on Monday on the public order charge. This inquiry, which opened on Thursday, saw Mr. Burke make submissions over 3 hours, arguing that he was entitled to an order for release. Seamus Clark, senior counsel for the governor of Cloverhill Prison, argued that the detention was lawful. When the inquiry returned just after 10:40 a.m. on Friday, Amy Burke made submissions for some 2.5 hours, arguing it was not being run as required by the Constitution. She argued her brother had been disadvantaged in being misdirected into making his arguments first, and maintained the governor was obliged to go first to defend the detention. The judge ruled against Miss Burke around noon, but she persevered for a further hour with similar arguments, to the mounting exasperation of the judge. Just after 1 p.m, the judge said that in 30 years in this business he had never seen a solicitor conduct themselves as she had, and had never been harangued in such a fashion. When the judge asked Simeon Burke about his position, Mr. Burke said the Article 40 procedure was laid down under the Constitution and the judge's duty was to follow it. The judge said he was carrying out his duty, and noted that the Burkes had by then made the same complaint about the procedure some 34 times. He told Mr. Burke he's a student in the King's Inns. I have no doubt you have a great future as a barrister in front of you, but the inquiry must proceed as the court ruled. When Mr. Burke said the judge did not get to change the Constitution, the judge said that judges of the High Court had a right and duty to interpret the Constitution, and the inquiry would proceed. The court rose until 2:15, when the inquiry proceeded without any active participation by Mr. Burke. When asked did he want to call or cross-examine witnesses or make submissions, he repeatedly replied the inquiry was not in accordance with the law and the Constitution. The judge then watched the CCTV footage of the events on the March the 17th at the Court of Appeal, including footage of Mr. Burke being dragged out of the court and put into a Garda car. The judge also heard evidence from Garda Conor O'Dwyer and Garda Michael McGrath, both attached to the Bridewell Garda station, who were among the Gardaí involved in removing Mr. Burke from the Court of Appeal. Garda O'Dwyer said he asked Mr. Burke numerous times to leave the courtroom, but Mr. Burke refused. He said he told Mr. Burke outside he was arresting him on a charge under the Public Order Act, and that Mr. Burke was kicking and shouting and making obscene remarks about transgenderism. Garda McGrath said removing Mr. Burke was a fairly tough task. Asked by Mr. Clark whether he ripped the buttons from Mr. Burke's shirt, Garda McGrath said it was a very dynamic situation with little time for discussion. The level of force was proportionate to what we were meeting, which was pure obstruction on a level I have rarely seen before. One of the notable features of this case, though, and of the hearing yesterday, is that Mr. Burke has made these allegations about the Gardaí, and then, given the opportunity to cross-examine the Gardaí, declined to do so. It's interesting that Enoch Burke, his brother in the Wilson's Hospital case, in the substantive case between Wilson's Hospital School and Enoch Burke, refused also to cross-examine witnesses and test the evidence. The former principal, for example, Niamh McShane, and I think it was 3 other witnesses, were unmolested, as it were, from a cross-examination perspective. Their evidence was given unchallenged because Enoch Burke was outside the courtroom and did not cross-examine them. Moreover, he had summoned his own witnesses, the religious persons involved, who were in attendance in the High Court for a number of days, and they were not cross-examined by Mr. Burke either. It's unusual and it's bizarre, quite frankly, that you will get into a litigation situation in law which is by definition an adversarial process, and that you'll make allegations about certain individuals, and then when those individuals give evidence, you don't cross-examine them. You don't test the evidence. You don't put your version of events to them. You let their evidence go unmolested, uncontested. Let me just posit a hypothesis to you. Let's say that the district court hearing or trial goes ahead on Monday next in the public order offence against Simeon Burke, and I gather from previous reporting of this case that there's going to be 5 witnesses for the prosecution. Those witnesses will be Gardaí. Those Gardaí will give evidence about the arrest, charge and caution, and about the various activities and behaviour that led up to the arrest on that particular occasion. let me ask you this. If those 5 Gardaí give evidence on oath in court, and if Simeon Burke refuses to cross-examine them, what is the judge supposed to do in circumstances where there's a conflict of evidence? Simeon Burke may well make a submission and say, I didn't do that and I was insulted and abused, etc., etc. by the Gardaí. The Gardaí go into evidence and give evidence on oath. If the Gardaí are not cross-examined, if their evidence is not challenged or contested, what is the judge, the district court judge, going to do? I have no idea, but you can make up your own mind. You can guess. And if you're a legal person, you'll understand that if evidence is untested and unchallenged, well then it's generally accepted. So it will be interesting to see whether he cross-examines the Gardaí on Monday in the district court. He didn't do it yesterday, and his brother Enoch didn't do it either in his case. As I say, it's an unusual situation. Law, by definition, is an adversarial process. It involves different versions of offence, different opinions, different narratives, different evidence, and it involves testing the evidence. It involves you taking your witnesses through your evidence. It involves you making submissions and assertions, but it also involves you testing the evidence of the other side, who are going to, by definition, provide a different story, a contrary narrative to yours. Anyway, hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.